Hello. I want to introduce you today to ADR Plus, which has been created by myself and John Virgo. And you'll hear from us both in this talk today. COVID-19 has been the midwife to ADR Plus. Those of you who are looking at this in, so to speak, real time for when this is being recorded, will know that in July, which is when I'm doing this recording, the court system froze in the early part of the year with hearings adjourned off, and mediations effectively were frozen as well. As time has moved on through the late spring and summer, the courts have restarted, but there have been inevitable delays and considerable difficulties, especially with larger trials and the sort of everyday hearings that would be slotted one after another in short order, many on a day. Mediations have also started, but they lack the intimacy of people being in the same building, moving from room to room, talking to each other, having the joint sessions when everyone could see each other across the table. That has all really gone for the moment. And it was in that context that we thought of an alternative system that would give many of the advantages of both systems, but it could be operated despite COVID. And in fact, it's a system that we hope people will use for the indefinite future, because we think it has real advantages, especially, and can I emphasize this, in the early stage when solicitors exchange correspondence, as commonly happens. And there comes a while or a time shortly after they get involved when they may think, well, this needs sorting out. We can keep exchanging correspondence, but we're not going to get a solution between ourselves. So we need something to bring a conclusion on. And that's where ADR Plus could be fantastic for their clients, saving them money in the long run and saving them the length of a trial or even getting to a mediation. So let's look on. As I say, it was created, this new route, by John and myself. It avoids the difficulties created by COVID-19 completely. It's simple, it's quick, and it's economic. And that's why we stress that it's a good idea to try it sooner rather than later. Vital elements of it are helping the parties to reach their own agreement, and it seeks to help them to do so. But if they don't reach their agreement, then there is a quick, authoritative and binding decision coming their way in short order. And we'll look into that a little further now. So it's a two-stage process. Stage one, the parties send their respective cases to an accredited barrister. And the parties also send forward any open suggestions for settlement, any ideas they've had which may not have found favour with the other side, but at least give the barrister an idea of the room for manoeuvre on each side. And it may be like a classic Venn diagram. He can see the circle on one side that one party will go to, he can see the circle that the other party may go to, and he sees whether he can pull them together and overlap them. The barrister produces a report, and that is a suggested way in which the parties might resolve their dispute. It's not binding on anyone. It's simply, having looked at it, another set of eyes, the barrister considers whether a solution might be possible. And I'm sure this is true of John, but it's certainly true of me. I've seen a number of cases where the judge, during the judgment or during the case, has said in effect, well, it would have been so much easier to have solved this by a simple practical route. I can think of one particular case where the judge said, well, if only they decided to put down some strips of concrete on the right of way that was being damaged, wouldn't have cost very much, the parties wouldn't have ended up in court. Having produced his report, the parties then give themselves, but one would usually think of it in these terms of 21 days, to see whether at the last minute, before the axe comes down, they can reach a compromise. The same sort of feeling that you get outside the doors of the court. And that 21 days is chosen because it shouldn't be too short, because otherwise the parties won't get time to throw ideas backwards and forwards, nor must it be too long, because otherwise they just ignore it and come back to it a few days before the deadline. So it's important to have that time period. The solicitors can agree to adjust it between themselves in advance, and in due course they can agree to extend it. But that's the basic period in which the final negotiations can take place. And then we go on to the second stage, assuming they don't. And that is, at the same time as he or she produces the report, the barrister produces an expert determination, which he keeps under wraps. Now, it may not be produced at exactly the same time because barristers have various commitments, but the idea is that about the same time as producing the report suggesting potential settlement, the barrister also produces an expert determination. And if the parties haven't reached their own agreement by the end of the 21 days, or whatever period is allowed under the first stage, then the barrister publishes the expert determination. And that effectively binds the parties. And John, in a moment, will talk you through the importance of an expert determination. But that's the two-stage process. So you notice it produces finality. And the parties know when they enter this process, there will be finality. So it's finality at a pace. Our best estimate is that the process should take about 6 weeks, start to finish. And the parties know when they enter this process that by the end of it, it will be done and dusted. Their dispute will be sorted one way or the other. Of course, the costs of this are minuscule compared with going to court, and very modest indeed, potentially, even in relation to a mediation, because mediations often occur very late in the process, after a great deal of solicitors' correspondence and starting the court process and all that sort of thing. Now, the process itself is very simplified, and deliberately so, to make it easy for solicitors to follow through. This is not meant to be a system that needs the specialist skill of an experienced litigation solicitor. It's not that sort of thing. It's self-contained, simplified, stripped down, but fair. What we've done is we've provided an agreement which the parties sign, which is incredibly brief, which I'll show you later. A checklist. This is the important thing in some ways, because it guides the solicitor through everything they have to do in simple steps. And then lastly, there are terms and guidance, which are detailed that the solicitor needs to read, which set out the contractual provisions and so on. We hope that this system, because it is quick, efficient and economic, will outlive COVID and continue to help people in the indefinite future. Now, we should talk about accredited barristers. Now, this is a pilot scheme. And so John and myself have effectively accredited ourselves based on the fact that we both have considerable experience in arbitration and expert determinations and mediations. In due course, if the scheme expands, we will provide training to other barristers in expert determinations and provide them with accreditation for the purposes of this ADR Plus scheme. This in due course will therefore provide a broad spectrum of expertise so that anyone using ADR Plus will in due course have a choice of barristers. They can select the most suitable that they think for their particular case. So we're starting on a narrow focus, but in fact in a wide area of practice. Now, we should tell you something about our own practices. You can see from this slide that for myself, I do a great deal of property work and options, mortgages, restricted covenants, a great deal of time on proprietary estoppel, wills, and so on. And in the commercial sphere, I do contractual disputes, construction of contracts, guarantees, a lot of partnership, company banking, as well as some company work, especially shareholders dispute. So that's look on that as just a global view of the sort of work I cover. And now we'll do the same with John. John has huge experience in banking and financial services, product mis-selling, swap mis-selling, LIBOR, contractual disputes, professional negligence, and insurance coverage disputes, and so on. In addition, he covers professional negligence. He's very well known for this on financial advisors, accountants, and so on. He does international offshore work, and he also does property and estates work. So you can see we cover between us a very broad range of work, both from the very modest to very large and interesting, wide-ranging work. And so that is the first the ambit of the first accredited mediators, accredited barristers that are, so to speak, open for you to use on this scheme at the moment. In addition, I, of course, have dealt with numerous mediations. I'm not a mediator, and from time to time, I've been written to by solicitors on a joint basis, asking me if I would provide an opinion on a matter of dispute, which in effect has been a sort of expert determination for their respective clients. John sits as an arbitrator in LCIA cases. He has acted as a mediator in any number of disputes and has experience in expert determination work. So again, there is experience there for us as the pilot barristers in ADR Plus. Now I'll pass over, if I may, to John Virgo, who's going to talk to you in more detail about expert determinations.
Malcolm, thank you very much. That description of the ADR process caused me to think that it might be helpful to contrast that offering with the various forms of alternative dispute resolution machinery which currently exist, because whilst they are beneficial in their own individual ways, each suffers from particular defects or drawbacks which we think do not afflict the ADR process that Malcolm has put forward. The first and obvious alternative dispute resolution forum, which is available in the context of financial services disputes, is of course use of the Financial Ombudsman Service or the Pension Ombudsman Service. The disadvantages of the Financial Ombudsman Service are that, in the first place, there is a financial cap, of course, on the value of any award that the FOS can make, which from the 1st of April this year has been set at £350,000. There's also a pretty strict 6-month time limit for referring a matter to the FOS, which runs from the date of the final determination letter by a financial regulated institution which is responding to a complaint. The FOS process is, of course, also vulnerable to judicial review, and those challenges, which are by no means infrequent, can be expensive and time-consuming. A recent example, concerned the case of Mr. Charlton, who made a complaint against Barclay Burke SIP Administration Limited in relation to the arrangement of a SIP, a self-invested personal pension plan for him. That complaint resulted in an award in his favour, which was then stymied by 6 years of satellite litigation, which ensued, challenging its enforceability. In the same way, decisions by the Pension Ombudsman are vulnerable to appeal under points of law under Section 151 of the Pension Schemes Act 1993. Outside the context of financial services, in the construction and surveying fields. There are, of course, and have been for some time in the construction field, the process of adjudication as an interim form of ADR. I well remember when that was first introduced, being concerned with a very large number of cases challenging the enforceability of an adjudicator's decision based on lack of jurisdiction or alleged lack of jurisdiction, based on allegations of breach of natural justice, or asking for a stay of enforcement in any event. And likewise, the more recent RICS adjudication process is capable of being rendered less effective by the aggrieved participant in that process deciding to take a matter or press a matter to court proceedings in any event. I'm involved at the moment in an RICS adjudication case, which resulted in the adjudicator making a finding of negligence. The claimant then set about enforcing that decision, only to be met in litigation with a defence raised that the claim was time barred under the Limitation Act, and that remains yet to be resolved. The third non-litigation ADR process is, of course, arbitration. That in itself can be expensive, not only in terms of the legal fees which are generated by the process, but also the need to pay for the arbitrator himself or herself. And arbitration awards are frequently appealed, whether on grounds of irregularity or points of law raised under Section 68 and 69 of the 1996 Arbitration Act. Irregularity appeals are rarely successful, but it is a fact that in the period 2015 to 2018, 30% of the commercial court business was concerned with appeals against arbitrator awards. I comment then on litigation. The recent Business and Property Court report for the last year end showed that 830 claims have been issued in that jurisdiction. We all know that even with cost budgeting, that process can be exceedingly expensive and involve inevitable further risk of costs in the event of an appeal. Now, it's against that background that the use of an expert determination can be immediately seen to be much swifter and much more cost effective. It's common enough as a process in accountants' valuation of shares, or the use of expert valuers to determine valuations of property and property, or construction property disputes, or the use of lawyers to construe clauses in commercial or property contracts as discrete issues. But we think that this whole process has scope for a much wider role for it to play in dispute resolution. It was Lord Justice Moore-Bick in Premier Telecommunications Group and Web who commented that parties who refer a matter to an expert for a decision usually do so in order to obtain a quick and relatively inexpensive decision of a binding nature on a matter that calls for informed judgment. And as that pithy quotation immediately exposes, the most important aspect of this process is to define the matter that is being remitted for determination, which can comprise one or more issues, and it's that which determines the expert's mandate. A decision made within mandate is not realistically challengeable, and as this and the following slide shows, that where the parties have chosen to resolve an issue by the determination of an expert rather than litigation or arbitration, the expert's determination is final and binding, provided it is made within the scope of the mandate that has been remitted. And there's a distinction that then falls to be drawn between the expert observing the mandate and simply departing from it. But provided the decision is made within mandate, it is effectively unchallengeable. And for all practical purposes, therefore, the expert determination does what it says on the can, i.e., it is quick and relatively inexpensive.
Well, thank you, John, for that discussion of expert determinations, and I will now take you through the 3 documents that comprise the ADR Plus system. They are the agreement itself, the checklist, and the terms and guidance. So first of all, the agreement, and the totality of the agreement is on the screen now. You can see it is designed for simplicity. The parties have to be named. The terms of the terms and guidance are incorporated. The barrister in section 4 is identified, and that the contractual arrangements with him only bind when he accepts the appointment. The checklist is incorporated in tab 5, and then 6, the fees of the barrister are to be shared as set out there, and it's just signed by the parties. I don't think you could have a simpler agreement, and in some ways it's rather similar to the first page of the standard conditions of sale or something like that. So that's the agreement. That's hardly going to tax anyone. And then we go on to the checklist. Now, the checklist is very important because it effectively guides the whole process. It makes things as simple as possible for the solicitors who are participating in the scheme. And I'm going to go through the checklist, the whole of it. And it starts by the bundle, because there has to be a bundle sent off to the barrister. And it's in 2 parts, really. The first part, which I'm looking at now, is the part that's agreed between the solicitors. And then there's a second part for all the documents that aren't agreed. So anyway, this part is that the bundle should contain, and won't be more than 300 pages, because we're hoping that these ADR processes will be kept in bounds in terms of documentation. But of course, it's always possible to approach the barrister and say, well, this is going to be different for one reason or another. It should have a list of contents, a summary of the dispute, a list of issues for determination, a chronology if people think it's going to be useful, relevant and useful correspondence in chronological order, please, key contemporaneous documents relied on by the parties, any party, and a copy of the agreement, the document we've just been looking at, signed by the parties. So you can see that gives a complete first guide to the first bundle. The second part is the documents that may not be agreed. And again, this is now each party sends off, instead of the combined one, their own individual one. And it includes any documents not agreed, statements of fact with a statement of truth. And we've used, I should say, not the most up-to-date statement of truth, because that is in effect a precursor to a contempt application. So we've gone for a straight, I believe the facts stated in this witness statement are true. Expert reports, if there are any, legal submissions, other submissions, arguments, but they can be incorporated together with the legal submissions. And there's something gone, anyway. Copy authorities referred to, and a signed copy of the checklist signed by each solicitor. So again, having worked through it and ticked boxes and one thing and another, at the end of the process of going through the checklist, it should be signed off, put in the bundle, and sent off to the barrister. So that's how we set up the documents, first of all, so that the barrister gets what he expects to get in an order that everyone understands he'll be receiving. Next, fees. Now, what fees should this process entail? One must appreciate that this process avoids, hopefully, lengthy inter-solicitor correspondence. It avoids the issue fee if litigation is brought, which can be up to £10,000. It avoids pleadings, statements of case in one form or another. It avoids all the pre-trial work. It avoids brief fees and court fees. So although barristers have to be paid and they charge a respectable fee, they are in fact doing 2 jobs. they're doing, first of all, a review of the case and seeking to produce a report which helps the parties reach a solution amenable to themselves. And separately, they're doing an expert determination and again producing a document which sets out their determination. So the barristers are doing a fair amount of work on this, and they are saving a great deal of time and cost for the parties, and potentially doing a job that sorts out their dispute much quicker than virtually any other system could do. The next part of the checklist sets out the timings, and this is for the parties to decide between themselves, but it's very straightforward. The first box is how long the barrister is going to be given to decide whether he wants to accept the instructions at all to act, and then how long they expect him to produce the report, and then this last box would normally be 21 days, but it can be another period, the gap between publishing the report and publishing the expert determination. So you can see the parties will know when they fill in these boxes how long they have to wait for things to happen and how long it will be before their dispute is sorted out, done and dusted, as I said earlier. So none of this is rocket science to deal with, and I'm sure solicitors will find it very straightforward once they sit down with it in front of them. Next, the solicitors have to give certain confirmations to the barrister. First of all, that they won't send things to the barrister without sending it to the other party. Secondly, that they told the client, made sure that he or she won't communicate with the client, and that the bundles, and this is important, don't include without prejudice, quarter bank or Part 36 form letters. If there's any doubt about it, then the parties should consider how to approach that question and perhaps approach the barrister for a view on the particular document that there's a dispute about whether it should go into the bundle or not. But anyway, those are, again, simple confirmations that solicitors can give to the barrister, ticking off through this checklist. Lastly, and you can see how quickly we've gone through this, lastly, there's a question sometimes in property disputes anyway, and in some other commercial disputes, not very many, but some, whether a site visit would help. And again, that can be filled in as appropriate. And so there we've dealt with the checklist. And if a solicitor sits down and just works his way through this, it will guide him through the complete system. Now, separately, the third document is the terms and guidance, and I've got a copy of it here. You can see it's just a few pages, but it sets out some important matters. It's a self-contained mini procedure. Some of you will be familiar with the White Book, or in former times the Green Book, and other books of procedure. And the whole object of ADR Plus is to cut that right down to the bare essentials to still achieve fairness for the parties. It contains, as it must contain, the contractual terms for the tripartite arrangements which underpin ADR Plus between the barrister and the solicitors acting for their parties. And solicitors must read it, of course. It doesn't take very long, 5-7 minutes to go through it, and I'll show you in a moment a section from it just to give you a flavour. One of the important features of this whole process is that it does not include disclosure. Disclosure, as litigation solicitors will know at least, is an expensive and time-consuming process. And we've made the strategic decision not to include disclosure in this process. Of course, parties can put their cards wholly on the table, and that, in many circumstances, I find, always looks good to a person determining a case. But it is not a part of this process. It's not something that parties are obliged to do. And also in the guidance notes, or within the terms and guidance notes, there are in italics notes designed to assist the parties in carrying forward the ADR Plus process. Now, this is an example page of part of the terms and guidance, and this page deals with expert evidence and lay evidence. And as you can see, it says, and we hope it's done in straightforward language, the parties are entitled to adduce whatever expert evidence they wish. And then secondly, if expert evidence is produced, it should conform with the usual practice directions. And then lay evidence simply should have a statement of truth attached, and you've already seen the statement of truth, and that's prescribed in the terms and guidance. So that's an example page just to show you what you'll be reading when you read through the terms and guidance document. And finally, all this documentation will be available on links to our individual entries on the Guildhall Chambers website, and you can always come back to this website as a refresher course. And finally, of course, ADR Plus always welcomes feedback, any feedback. And now I'll pass you back to John for some concluding remarks. Thank you very much.
And so some concluding remarks after Malcolm's helpful description of the more granular detail of the process. It occurred to me, listening to Malcolm's description of the process, that sitting as I occasionally do as an arbitrator in the London Court of International Arbitration, what the parties end up with is, in substance, no more than a view, a combined view, usually of the triumvirate of arbitrators, as to the facts of a particular dispute, and then an attempt to resolve that dispute by applying the law, as we understand it to be, to the facts as found. The process of an expert determination via ADR Plus is not markedly different. Effectively, what you are ending up with is an assessment, an evaluation of the facts based on the materials provided, and then a decision based on the barrister's understanding of the law as applied to those facts. And for all the reasons that have just been outlined, we consider this is a swift and efficient, effective alternative way of resolving disputes inexpensively, and we're happy to commend it to you. Thank you.